Hi guys, do you all know that there is a new Trademarks Act 2019 which replaced the Trademarks Act 1976?
Really?
Yeah, I just know about this recently.
I think not a lot of people know about this, right?
That's true. Let's explain it together.
Hi, I'm Zhi Chen. So I will start off with the introduction. So what is a trademark? A trademark is any sign that individualizes of a given enterprise and distinguish them from the goods of its competitors. Usually, a trademark can be used to communicate with the consumer not only through the goods bearing the mark, but also in advertising. Despite going through many amendments exercise, the legal framework is no longer accommodative to the present needs and international business community. The Malaysia Trademark Act 2019 is a more comprehensive piece of legislation. It enables Malaysia to fulfill its obligation under international treaties such as the Madrid Protocol. It is submitted that the new Malaysia Trademark Act 2019 have various improvements as compared to the Trademark Act 1976. But at the same time, the 2019 Act has its inadequacy. In this video, my teammate and I will be focusing on some major features that were introduced in the 2019 Act and how this new Act is significant as compared to the Trademark Act 1976. First of all, one of the major changes in the Malaysia Trademark Act 2019 is that now it allows multiple classes of goods and service applications to be made at the same time. Now, following the introduction of multiple classes, division, and merging of application or registration mechanism will be introduced to facilitate the management of trademark application. With this, brand owner who wish to register its trademark in several classes now have the option of applying for registration of the trademark by way of a single application covering all the classes of interest. Compared to the Trademark Act 1976, this promotes convenience and efficiency in portfolio administration and management, as an applicant need only keep track of one trademark application instead of multiple trademark applications with possibly different filing and registration dates.
With the enactment of Trademarks Act 2019, Section 2 now recognizes the registration of unconventional trademarks, including color, sound, scent, hologram, positioning, and sequence of motion. Although Part 4 of the Trademarks Act 1976 allows for registration, it was not as comprehensive as the 2019 Act, where it allows for the registration of the aforementioned unconventional trademarks. That said, it is important to have trademarks registered as they will affect a business's performance and are considered as fundamental economic assets for the organization. Besides, it can be useful for various stakeholders in assessing such intangible assets with the company's performance. Additionally, having a trademark registered indicates a source of visibility and reputation, which will eventually become a strategic asset to companies competing on the basis of product differentiation and customer loyalty. It also serves as a form of protection against competition, as by registering a trademark, a barrier is effectively built in inhibiting competitors from using one's brand. That said, being in an information age where communication and commerce via the internet is becoming a central focus for businesses, consumers, government, and the media, the usage of unconventional trademarks of a product in promoting goods and services is very attractive, hence highlighting the importance of registering unconventional trademarks. This is especially so where consumers purchase products from businesses according to the aesthetics of a product and their own personal preferences. Not just that, with trademarks increasingly inspiring brand loyalty among consumers and customers, it is said that scents are perceived to be even more effective in invoking loyalty affinity among consumers, as scents could induce feelings, ideas, or understanding of belonging and affection. Besides, by registering a trademark, a registration certificate is then issued by the registrar's office. This serves as prima facie evidence of trademark ownership of one's goods, especially as proof when exporting such goods to other countries. This links to the next point where Malaysia is now a signatory of the Madrid Protocol. Malaysia's accession to the Madrid Protocol is found under Part 12 of the 2019 Act, which enables businesses in Malaysia to protect their trademarks internationally in 122 countries around the world, thus making Malaysia accessible to the global market. Besides, where an applicant applies for trademark registration under the 2019 Act, simultaneous registration of trademarks in several jurisdictions is now possible with the filing of just one application. Whereas under the 1976 Act, applicants will have to file for separate applications in each country where it seeks to protect its trademark. This had been troublesome for the applicants as they were further advised to take all the necessary steps in avoiding the possibility of a central attack. That said, with the 2019 Act coming into force, such worry need not be considered, subject to the regulations set out in Section 75. With the need of filing for only one application, the cost for international trademark protection is significantly lowered, as applicants will only have to pay one set of fees in a single currency. This would further promote the registration of trademarks among business owners within Malaysia, in enabling to protect trademarks internationally and for the trademark owners to enjoy the benefits of the centralized management system that the Madrid Protocol offers. Besides, having such a membership benefits the government as well. It is now easier for the government to keep up with the latest intellectual property developments, where dissemination of information and updates on current issues can be done more extensively and effectively. Moving on, as emphasized earlier on the importance of registration of a trademark, it is especially important where there is an enforcement of rights in bringing legal action and against infringement, as per Sections 48 subsection 2 and 56 of the 2019 Act. However, where such legal action involves unregistered marks, Section 159 subsection 2 of the 2019 Act provides for legal recourse through the common law of passing off. Such express recognition of passing off is significant, as unregistered trademarks infringing copyrights can now be brought in action against, unlike in the 1976 Act where such recognition was not provided, which eventually led to loopholes in the statute. This is because a statutory infringement action and a passing off action have very distinct elements of liability, thus suggesting that being able to claim for an infringement action does not equate to being able to claim for a passing off action. This was the case in Jordache Enterprises Incorporation against Millennium Pte Limited, where the court held that an infringement action could be claimed against, but the passing off action failed as there was a lack of sufficient goodwill. That said, with the limited protection under the 1976 Act, passing off could be used easily against trademark owners, since it is based on the proposition that nobody has any right to represent his goods as the goods of somebody else. As such, by virtue of Section 159 of the 2019 Act, only registered trademark owners are able to initiate action in preventing infringement, unless it can be proven that passing off can be relied upon, in which has been proven to be difficult in establishing goodwill, as per Inland Revenue Commissioner against Muller and Company's Margarine Limited, where Lord Macnaghten has stated goodwill to be worth nothing unless it has power of attraction sufficient to bring customers home to the source from which it emanates. The issue then arises as to what then is the significance of registering trademarks under the 2019 Act, when passing off is able to protect the aforementioned unconventional trademarks. That said, it should be noted that Section 62 provides that the property in the registered trademark itself is being protected, while passing off provides the protection of the goodwill of the businesses using the trademark. As such, it could be said that in an action for passing off, the claimant will have to prove the reputation in the country that his business or products is attached to. This is the case even where the trademark is well known internationally, as seen in Lim Yu Sing against Hummel International Sports and Leisure AS, where the Court of Appeal held that there was no infringement of trademark as the respondent did not acquire any reputation in this country. This is contrary to the wide protection that the 2019 Act provides, where an action for infringement may be claimed even where the registered trademark is conducted in another locality within the ambit of the Madrid Protocol.
Moving on, another notable and significant change made to the Trademark Act 2019 is the person entitled to initiate action for trademark infringement was expanded to include licensee. Under the Trademark Act 1976, certain rights are limited to only registered user. Nonetheless, following the new Trademark Act 2019, a licensee is also entitled to bring infringement proceedings against the infringer in his own name. A licensee now shall be entitled to call on the registered proprietor of the trademark to take infringement proceeding in respect of any matter which affect his interest. These changes have significantly increased the protection of trademark. As compared with the Trademark Act 1976, it only provides the protection to a registered proprietor on the purpose to defend the proceedings on the basis of non-use. It is noteworthy that the right of a licensee is not governed under the 1976 Act. Presently, the new 2019 Act included exclusive license. An exclusive license means a license which allows the licensee, to the exclusion of all the other person, including the person granting the license, to use a registered trademark in the manner authorized by the license. With the Trademark Act 2019, including the licensee, trademark owner now have a more practical and flexible ambit to pursue an infringement action, whereby an infringement can be arised by a licensee. they have the same rights as registered proprietor. It will be easier for trademark owner to now commence legal enforcement such as action against act of passing off without having to go through the hassle of applying to the court for registration, as any such rights and remedies of an exclusive licensee are concurrent with those of registered proprietor.
Hi, I'm Ern Chee, and I'll be talking about another significance of the Trademarks Act 2019. The Trademarks Act 2019 is significant as compared to the Trademarks Act 1976 because it has maintained and expanded the defences for trademark infringement. The defences under Section 40 have been maintained in Section 55, subsection 1 and 2 of the Trademarks Act 2019. By preserving the defences available, it retains the protection given to innocent users from trademark infringement. Not only that, the significance of the Trademarks Act 2019 is seen when it further expanded the acts not constituting infringement to include use for non-commercial purposes, for news reporting or commentary, or when there is consent by registered proprietor or licensee of trademark. For defense of use for non-commercial purposes in Section 55, subsection 3a, it can be said as superfluous because the prerequisite for infringement under Section 54, subsection 1 is that the use of sign must be in the course of trade. As for the defense under Section 55, subsection 3b, which is for news reporting or commentary, the rationale is that logically the use of trademark in the course of news reporting or commentary will not confuse the public as to the trade origin of goods, so it does not constitute infringement. Also, the defense of consent by registered proprietor provided in Section 55, subsection 3c is in line with the well-established principle in landmark case of Winthrop Products and another and Sun Ocean Syndrome Berhad, whereby the subsidiary company, who is the registered proprietor of Panadol trademark in Malaysia, has impliedly consented to the use of trademark when the subsidiaries in other countries have sold their products in their countries. The subsequent significance of Trademarks Act 2019 is in terms of remedies, as it has codified remedies available for a registered proprietor of a trademark. The remedies are found in Section 56, subsection 3, whereby the court may grant relief of injunction damages, account of profits, or additional damages for counterfeit trademark. Also, Section 58, 59, and 60 provides for the remedy of delivery up, which includes remove, erase, destruction, or surrender of infringing goods. Having these remedies codified in Trademarks Act 2019 is undeniably significant because previously such remedies were only available in case laws. By codifying all of the remedies available for a registered proprietor, Trademarks Act 2019 provides more certainty in law, as opposed to the previous act, which is silent on remedies. Another significance in terms of remedies is that Section 56, subsection 5 allows the court to award damages along with an account of profits, provided it has not been taken into account in computing damages. In contrast, before the Trademarks Act 2019, plaintiffs have to elect between damages and account of profits, as seen in Longman Malaysia Syndrome Berhad. This change in law is significant as it allows the court to take into account all of the losses suffered by the plaintiff in assessing compensation. Therefore, the plaintiff has a higher chance of obtaining more compensation. Last but not least, another significance of the Trademarks Act 2019 is that there are provisions on criminal enforcement and penalties under Part 15 and 16 of the Act. Previously, under the Trademarks Act 1976, there was no provision regarding criminal enforcement and penalties. Therefore, the Trade Descriptions Act 2011 had to be referred to. This shows the lacuna in the previous act. The current Trademarks Act 2019 contains important offences such as the offence of counterfeiting a trademark under Section 99. Counterfeiting is an act of making a sign identical or similar to a registered trademark to imitate a genuine registered trademark, whether by alteration, addition, effacement, or partial removal. It is a serious crime which is criminalized in various jurisdictions such as in India, United Kingdom, and United States. Such an act is the most egregious form of trademark infringement, as the infringer gains profit on the expense of the registered proprietor by harming the reputation of the brand. As such, there is definitely a need to criminalize counterfeiting, and Trademarks Act 2019, which recognizes counterfeiting as an offense, has made a significant improvement in Malaysian trademark laws. Also, the Trademarks Act 2019 has expanded the provisions relating to enforcement and penalties, such as the additional offense as seen in Section 101 regarding the act of making or possessing an article for committing an offense. Therefore, the Trademarks Act 2019 is now a unified avenue for criminal enforcement and penalties.
Although Trademark Act 2019 can cover all the situation in relation to the infringement of trademark, it is also possibly to argue that the Trademark Act 1976 is more specific than the 2019 Act, particularly under the issue of proving the likelihood of confusion. Under the 1976 Act, it was clear that the main thrust of the law was to protect the primary function of a trademark as an indicator origin. For instance, the definition of a trademark in Section 3, subsection 1 emphasized the connection between the goods or services with the registered proprietor, and the infringement provision in Section 38, subsection 1 protected only the origin function of a trademark. The position under the Trademark Act 2019 is less clear on this point. On one hand, Section 3, subsection 1 defines a trademark in relation to its original function of distinguishing goods or services of one undertaking from those of other undertaking. On the other hand, in determining the likelihood of confusion on the part of the public under Section 54, subsection 2, infringement, reference must be made to Section 9, subsection 2 of the Act. To analyze, follow the Trademark Act 2019, the owner of a trademark does not need to prove that the public is confused as to the source or the origin of the goods or services offered under the trademark. Nevertheless, Section 9, subsection 2 requires the use of the sign to be associated with the registered trademark. Hence, this would result in confusion about the likelihood of association because the public tends to relate the good or services to its original registered proprietor, and this would fall back to the definition provided under 1976.
The Trademarks Act 2019 is arguably insignificant as compared to the Trademarks Act 1976, as it has removed provisions regarding defensive trademarks. The purpose of defensive trademarks is to prevent deception of the public, which might result in a third party appropriating trademark which is well known. A defensive trademark is also vital as it is more cost-effective and convenient than bringing an action for trademark infringement when the third party misuses the well-known trademark for their own benefit. In this sense, a defensive trademark is clearly beneficial to a registered proprietor of a well-known trademark and should remain registrable in Trademarks Act 2019. Even though Section 166 states that defensive trademarks registered under the previous Act will be deemed registered, it will no longer be immune to cancellation on grounds of non-use. As such, it can be easily cancelled and cease to exist. Thus, it can be said that the Trademarks Act 1976 is more significant as compared to the Trademarks Act 2019 in terms of defensive trademarks, as it is only allowed in the previous Act.
In conclusion, the Trademark Act 2019 is definitely more significant as compared to the Trademark Act 1976 in terms of registration, infringement, defenses, remedy available, and enforcement and penalties. Although the Trademark Act 2019 also has its inadequacy, such as the confusion arises under the element of likelihood of confusion and the removal of defensive trademark. Nevertheless, as there are only limited inadequacy in Trademark Act 2019, the Act remains more significant than the Trademark Act 1976 and is set up to significantly change the existing Malaysian trademark landscape. It has also enabled Malaysia as an attractive base for trademark filings, with now Malaysia being a frontier of a trademark development on international and national front.
That's all we have to explain on this topic. Hope you enjoyed it. Bye.
Bye.